Welcome back to La Belle Vie. Today I'm going to provide a brief update on the Sarah Boone Suitcase murder case. Not a ton has happened since Sarah was appointed new counsel in September of 2023, but there have been a few motions, so I thought we would go ahead and have this quick update. Okay, let's get to it now. Okay, so as mentioned, Sarah has a new lawyer. This is her seventh. His name is Winston E. Hobson. He is a member in good standing with the Florida Bar since 2001. He's also licensed in New York since 1999. He graduated from Drake University Law School in 91. I did not find any known complaints for him under either Florida or New York. He appears to focus on criminal law based on the case research I did, which also makes sense because his focus is listed as criminal law on the Florida Bar site. He was appointed again as Sarah's lawyer on September 8th, 2023. He filed his appearance and not guilty plea on behalf of Sarah on September 16th. Since being appointed, he has filed several motions. The first was a motion to reappoint a private investigator, which was granted by the court on December 20th, 2023. And he has filed two other motions, which we'll get to shortly. Okay, so another update is we have a new judge. I'll be sad to not see Judge Wayne Wooten anymore, but we do have a new judge. His name is Michael Kranick. He was appointed as Sarah's new judge in January when he was assigned to her case. And actually, I'm going to link now to his bio page. Okay, you'll see here he's been a judge since 2019, where he started off as a circuit judge in Osceola County in family court. Then he moved up to Orange County in domestic relations. In 2023, he was a circuit judge in Orange County for domestic violence. He also then served as an associate administrative circuit judge in domestic relations. And then, of course, in 2024, he was appointed to be a circuit judge in the Orange County Criminal Division. As mentioned here, he went to Barry University School of Law and he went to FSU for undergrad. And there you go. So there is Judge Kranick. And again, as mentioned, he went to Barry University School of Law. He graduated in '07, and he was admitted to practice in the Florida Bar in September of 2007. So the motions was a motion to appoint a forensic mental health expert. So we're going to go to that now. Okay, so you'll see here, this was an ex parte motion, which meant it was basically done without the notice of to the other side or the state, for the appointment of a forensic mental health defense expert or similar expert, fact investigator, and for approval of other necessary due process costs. It said that the motion has been filed and submitted to the JAC, which is interesting because if you recall, Sarah's last lawyer, Bankowitz, had filed a motion to appoint another domestic violence expert, a battered spouse expert, and that motion was pending the time that he withdrew from her representation. Although the JAC had responded to that motion and had objected to it. So it will be interesting to see if the JAC objects to Mr. Hobson's motion. But you can see here he's asking either for a flat fee or an hourly rate as approved by the court. And of course, here's their argument for getting for justifying their motion. And it says here that to properly prepare for trial and to review testimony and evidence, Mr. Hobson requires the services of a forensic mental health evaluator to review the evidence, including meeting with other experts and testifying at hearings, to be able to understand the evidence relating to the crimes, the elements of the crime, the death investigation, and potentially to perform a crime scene reconstruction. I don't know that that could happen. It's an interesting point, right? Because one of the arguments I think that the state is going to make is that Sarah allegedly possibly shoved that suitcase down the stairs. So that might be interesting. Here's the individual that Hobson is recommending to be serving as this expert, and we'll talk about her in a minute. Linda DeRay. She's very qualified. And she's in Florida. She's in Winter Park. So she's right there. So that's great. They wouldn't have travel costs. She has served as an expert in many other cases. So that I think there wouldn't be any question on her being an appropriate expert. This is what I found to be interesting here is that Dr. Duray is a certified forensic mental health evaluator and has expertise in the areas of potential defenses in this case, to wit, battered women syndrome, which we've heard before. Both Sarah's other private lawyers, Mr. Padilla and Mr. Bankowitz, had both indicated that they would be pursuing a battered spouse defense. Domestic violence, generally personality disorders, battering husbands, infidelity, and alcoholic blackouts. Now, we're going to talk about that in a minute because I've talked about this before in my Sarah Boone content, that the limitations with anything that's alcohol related in Florida. So we'll talk about that. But in any event, this is her area of expertise. They're also saying that she requires a reasonable upfront retainer, which is pretty common. And they're basically saying that, here's her CV. And so therefore, please grant this motion. Now, again, this has not been granted yet by the court. So here's her website on law.com. She's listed as an expert witness. She's written a book, Surviving the Toxic Workplace.com, as mentioned. She is in Winter Park, which is right there. So very convenient for trial and for case prep. So she's been an expert witness for 48 years and a licensed psychotherapist for 45 years. She's been qualified as an expert in 11 different states. Yeah, I mean, personal injury law, employment law, family law, and criminal law. She has also consulted with attorneys on jury selection and strategy. And yeah, she's been on a bunch of TV appearances on Oprah, 60 Minutes, et cetera, et cetera, et cetera. So I don't think there's going to be any question that she is qualified to serve as Sarah's expert. I think the matter is going to be, does the JAC object to one, the defense having another mental health expert, and two, do they agree with her rates? So I think we'll just have to stay tuned for those responses. Now, as I mentioned, voluntary intoxication is not a defense in Florida. So I want to bring up that statute because I think it's important, because we saw, one of the things the defense wants to have Dr. DeRay opine on is alcoholic blackouts. So let's go to the statute. So basically, starting in 1999, voluntary intoxication is not a defense in Florida. So let's go through this because it's actually a bit broader than that. So, voluntary intoxication, not a defense, evidence not admissible for certain purposes, exception. Voluntary intoxication resulting from the consumption, injection, or other use of alcohol or other controlled substance, as described in Chapter 893, is not a defense to any offense prescribed by law. So, any felony, misdemeanor, anything. Evidence of a defendant's voluntary intoxication is not admissible to show that the defendant lacked the specific intent to commit an offense, and is not admissible to show that the defendant was insane at the time of the offense, except when the consumption, injection, or use of a controlled substance under Chapter 893 was pursuant to a lawful prescription issued to the defendant by a practitioner as defined in 893.02. So unless it's a properly prescribed drug, it can't be used not only as a defense in Florida, but also to show that the defendant did not have the specific intent to commit the offense. Sarah's not going to be able to use the fact that she voluntarily, allegedly drank that white wine, that she therefore didn't intend to do anything that was reckless disregard, like not letting her boyfriend out of the suitcase when he's pleading for his life. So, as you recall throughout Sarah's police interview, she kept saying, "I didn't intend to do this. I didn't intend to do this." So, according to this statute, the defense would not be able to use the fact that she voluntarily drank wine is not a defense, she's not able to use that to show that she didn't intend to ultimately murder George, right? Allegedly. So, now that being said, I'm sure that the expert will use any type of issues with alcohol to possibly tie into the battered spouse defense. They could want to potentially use the alcohol for is in the event Sarah is ultimately convicted. If that occurs, they could use some of that evidence in mitigation evidence for sentencing. But again, you're not able to use it as a defense, and you're not able to use it to show that the defendant, Sarah here, lacked the specific intent to commit an offense. So they're not going to be able to use the alcohol for that. Now, the other motion that Sarah's lawyer has filed was recent, and it was a motion to continue. So we're going to go ahead and go to that motion now as well. Mr. Hobson did file this motion to continue and the waiver of her Sarah's presence at the hearing. And that's important because, as you know, in prior court appearances and in letters to the judge and to anyone else that would listen, Sarah was very upset about not having you know, being transported to her various court hearings. So, in any event, they've asked that the trial that was tentatively scheduled January 29th, 2024, which I think none of us thought was going to happen. And of course, the pretrial was January 16th. Mr. Hobson understandably says that additional time is needed to prepare for trial, that he's still reviewing extensive discovery. He's also, of course, seeking appointment of that expert, which we just went over, and acknowledged that the court had recently approved costs for a private investigator and the speedy trial has been waived. So that was what we had as far as the motions that Hobson has made on behalf of Sarah since he's been her lawyer last fall. Now, as I mentioned, they went ahead and had that hearing on January 16th, and we're going to go over that now. Thanks to Court TV for covering it. So we're going to go into their channel and watch it. It's pretty quick, but some interesting things that explain some things like this right here, final continuance. So it was a very short hearing. We're going to go to it now, but I have some things to say about this right here.
State of Florida versus Sarah Boone, 2020 CF 2603, state.
Dave Cacciatore on behalf of the state.
Mr. Cacciatore, good morning. The court was just made aware that a motion to continue waiver of presence was filed on January 12th, 2024 at 11:18 a.m. A copy of it was not favored to my office. My judicial assistant found it this morning by scouring the record once we did a call in the halls for counsel for Ms. Boone. The motion reflects that additional time is needed in order to prepare this case for trial. Counsel is still reviewing extensive discovery in this case and is also seeking appointment of experts with the S in parentheses. This court has approved costs for a private investigator. The task to be accomplished in preparation for trial cannot be concluded by the now scheduled trial date. Reflects that speedy's been waived and that you had no objection to same. Is that accurate with regard to your objection or lack thereof?
That is, and I've had the chance to review that motion, Your Honor.
I'm sorry, Mr. Cacciatore, say again, sir?
That is accurate, and I have reviewed defense's motion to continue.
Okay. The motion does not identify the amount of time that they're seeking a continuance. In your conversation with counsel Hobson, are you in a position to advise the court as to how long of the continuance they're seeking? Oh, no, the wherefore clause says 3 dockets. I apologize. Any objection to that, sir?
No, Your Honor.
Okay. The motion to continue will be granted. This matter will be continued for 3 dockets. Now, my understanding is that this is typically specially set. So do we want to have this especially set at a certain time, Mr. Cacciatore?
I think that would probably be better. Typically, Miss Boone has elected to attend many of these hearings um, and not waive her appearance at them. So I also think too that we're at the point that um, that we're close to being, I think, ready for trial, and that I guess without getting into too much more without Mr. Hobson here, yes, I think just we could set it for a special set status.
All right, the court has availability for a special set on May the 3rd at 9 a.m. The court's inclined to have this as a special or as a final continuance due to the age of the case and the motion not specifying anything more than a 3-docket continuance.
That's acceptable.
Okay, all right, we'll set this matter for a special pretrial on May the 3rd at 9 a.m. Ms. Boone we'll have a mandatory appearance for Ms. Boone at the May 3rd at 9 a.m. pretrial. What's the following trial period for
The trial period for May the 3rd would be May 13th.
with a trial period of May the 13th.
Thank you, Your Honor.
All right, thank you, sir.
So there you go, guys. That's what that means, final continuance. I think that this is serious. This is an older case, and I think this judge wants to move it along, but we'll have to see. So that's the update for Sarah Boone. I'm interested to see the outcome on the defense's motion to appoint a forensic mental health expert. And again, as I mentioned, remember Frank Bankowitz, Sarah's last lawyer, had filed a similar motion for a mental health expert last summer. And the JAC, which is the state agency that approves these costs because Sarah is indigent, had objected to that motion, both for reasons of there being another expert added and also for the amount that was being proposed. It will be curious to see if the JAC files an objection to this motion. There's nothing yet on the docket. I'll be looking out for that, and I'm also interested to see how the court rules on this motion. And then, as I mentioned, I found it very interesting that the judge made this a final continuance. And so I'm wondering, does this mean we might see a trial for Sarah Boone in May? So thank you again for joining. Again, I'll be sure to update once either the JAC files its response to the defendant's motion or the court rules on it. In the meantime, I hope to see you in one of my other videos, and I hope you have a great one.